Hi, I'm going to speak to you about employee shareholders, it's a brand new piece of law. So the initial idea is difficult to understand in that when the consultation happened on this new piece of law, there wasn't very favourable outcome and feedback, and yet here we are, it's gone ahead. So employee shareholders is with us now. So originally, the first part, I guess, is what was the plan. So the original plan was to try to find a way for employers to employ employees at less of a risk to themselves. And actually, really, all we have now is an exchange. So the first point of these 5 points is that this is an exchange of rights. The idea is to give up your statutory rights in exchange for shares in a company. And originally it was like the idea was to give it to for newly starting up companies, which is fine, except that there are a lot of issues, and a lot of issues came up during the consultations. One major issue is that you have a new class of employee. You've got employees, you've got various workers, the sort of cover-all for workers, but this is now employee shareholders. So we create perhaps what's a new status of employee shareholders. To my knowledge, this hasn't been tested yet, but it's certainly, you have a worker of some description, we're not quite sure what yet, who has a different set of rights from an employee, from a worker. And the reason for that is because they give up these rights in exchange for their shares. Originally, we had the Beecroft report, which was trying to bring in the idea of no-fault dismissals, which is really for the benefit of the employers, so that they had the opportunity to sack their staff much more easily and more quickly without the fear of going to the tribunal. In October 2011, the Beecroft report suggested that we should have a system where an employer can dismiss an employee without any fault. No-fault dismissals is what it was known as, and this is something that the government decided to try and spearhead, and it was recommended by Adrian Beecroft. Now the difficulty is that, of course, naturally the unions were not pleased, and so it ran into some difficult time. The first point is, what's the plan? It's an exchange of your employment rights for shares in a new company. It was recommended through a number of different ways. There was a consultation, but initially it started out with the same principle of no-fault dismissals. This was rejected mainly by unions and various other interested people. The Law Society were scathing of it. So we're now in a situation where, in order to limit or give the employers an opportunity to limit an employee's statutory rights, they created this idea. The government created this idea of employee shareholders, and in other words, you exchange your statutory rights for shares in the company you work for. So who is an employee shareholder? Well, the definition is in the statute. It's fairly straightforward. You are an employee shareholder if you have agreed to become an employee shareholder and you are given shares between a certain value. So what rights are given up? Well, in exchange for these shares of this certain value, you have to give up statutory rights, and it's not just the small scale stuff. The main points are the right to make a request for study or training, request flexible working, which is quite a serious point because, of course, there's quite serious discrimination issues here. We have a government who purport to be concerned about equal opportunities for people, and naturally flexible working is primarily used by women, or if not women, then carers of people with disabilities. So that gives a slightly difficult perspective on this law. But the main headline points, of course, are the right not to be unfairly dismissed, and a right to a redundancy payment, which are both given up as an employee shareholder. And of course, in exchange for giving up those rights, you're given shares in the company. So how will that affect the employees? Well, of course, they won't have the right to bring an action in the tribunal for unfair dismissal if they're a shareholder. It's just an employee shareholder, of course, not a shareholder in general. That means that there will be no procedure will need to be followed for dismissal. The ACAS code is irrelevant to these people, to these unfortunate employees. The need to consult for large-scale employees dismissals is no longer necessarily relevant. The upshot of this, of course, is that employees may fall behind if they're not given their training. The whole idea of giving a worker the opportunity or an employee, I should say, to request training is so that they can keep themselves in the loop in terms of developments. Well, that's not useful for a company. It's actually in a company's interest for them to go on training in many ways. Also, majority of business is done in networking. So, if these training sessions are an excellent way for people to meet other people in the industry, and they won't have the option to go to attend these trainings. The relationships won't be built in the same way. I've already mentioned that women and carers for perhaps disabled people are often the people who use flexible working, and if they give up the right to flexible working, then that could be discriminatory to those people who fall within the protected characteristics. How will it affect employers? Well, of course, employers will have the ability to dismiss, which is, I suppose, good for them in some ways. I'm not sure that having a workforce which is made up of employees who are scared for the loss of their jobs, is the best way to motivate them. It's probably a detrimental thing within the organisation. Furthermore, of course, flexi time falls within this definition, and job sharing as well. So what do the employees get in exchange? Well, they get shares. They get shares between the value of £2,000 to £50,000, which is the statutory limit there. That range is within the statute. So it obviously can't be less, can't be more. The benefit to the employee is that they don't have to pay capital gains tax on those shares, which is a deal struck between the Chancellor and the employees and the employers. Employees may also benefit from a dividend from those shares, although it doesn't appear to be any statutory framework for how that will fit in with current shareholders and the Companies Act, and furthermore how that will affect companies' articles of association, whether they will have to be amended, or shareholders agreements, etc. And shareholders agreements and articles leads on to the question of what rights these shareholders will have. It's not really clear whether they'll have a voting right, perhaps, or what the benefit, exactly what dividend they're going to get. None of these things seem to be in the statute, so it's rather difficult to know how it will work for the benefit of the employee. So that's employee shareholders. It's not an easy area. It's not a clear area because it's so new, and it doesn't appear that the change in the law has been thought through terribly clearly. But we will have to see how the courts develop the law and how they interpret the law. Thank you.